This is SJC 13179, Executive Office of Health and Human Services of the Commonwealth of Massachusetts v. Linda Marie Mondor, and SJC 13199, Laurie A. Dermody v. Executive Office of Health and Human Services of the Commonwealth.
Okay, thank you. Attorney Boodoo.
Thank you, Chief Justice Budd, and may it please the court. In each of the three cases before you today, married couples used their joint spousal assets to purchase annuities as part of a strategy for spending down one of the spouses into eligibility for mass health long-term care benefits. In each case, the spouse not in a nursing home, the so-called community spouse, was the named annuitant, the person receiving the monthly payments, and the Commonwealth was the first remainder beneficiary. And in each case, the community spouse passed away with payments on the annuity still left to be made, triggering the Commonwealth's remainder rights. The issue here is the meaning of those remainder rights. And that question turns on whether the relevant provisions of the Deficit Reduction Act apply to annuities like these. The Commonwealth's position is that those requirements do apply. And that position is consistent with the position of the federal government, consistent with the position of other state Medicaid agencies across the country, and consistent with the text and purpose of the underlying federal law.
Can I ask, Ms.
Oh, I'm sorry.
Go ahead.
Yeah, I was just going to ask whether there's a reason that the government's just now trying to recover these monies, given that the act was passed quite a while ago.
Chief Justice Budd, I'm glad you asked that question, and I want to be very, very clear about this. There has been no change in policy on this or enforcement since the 2008 amendment to Mass Health's regulations. I know the family beneficiaries are making this argument. I have followed the sites and their briefs, as I'm sure the court will. They are not relying on anything except a 2007 email that predates Mass Health's amendments to its own regulations. I want to point to two cases as well on this. The first is the Superior Court decision in Breslau, where the judge rejected the same argument that there has been some inconsistency in Mass Health's position on this. The second case is the administrative decision in Jackson, which is in our addendum to our opening brief at page 94, where there was a finding of fact in that case that the eligibility worker contacted their manager, who confirmed similarly that there has been no change in Mass Health policy on this. Can
I ask a couple of questions just to get myself up to speed? So the community spouse buys an annuity and doesn't name anyone, just buys the annuity. Doesn't name any beneficiaries whatsoever. The annuity is for, it's sort of a consistent with expected lifespan. No one's named. Why isn't that for the sole benefit? Why is that not for the sole benefit of that person?
Mm-hmm. Well, this is an issue that the concurring decision in the Hagedorn case, the recent Hagedorn case from Wisconsin, talks about, and that kind of hypothetical annuity where there's no beneficiary. I think that's what
Right.
Your Honor was getting at.
Right.
No,
I mean, I understand you're compelling the selection of benefit, but if say they don't do anything, they
Right.
just buy an annuity, don't name anybody, why is that not for the sole benefit of that person? I just don't understand that.
Right, and this in some ways gets to what the sole benefit exception was all about in the first place, right? So starting in 1988, Congress said, we're going to count all assets of both couples jointly for eligibility purposes. And at the same time that Congress does that, it creates the sole benefit exception. It says we're going to accept interspousal transfers from penalty, again, because we're looking at all the assets together anyways. The interspousal transfers don't make a difference to eligibility. They're Medicaid neutral. A transfer or a purchase of an annuity that isn't Medicaid neutral, that is designed to aid in Medicaid.
Again, in my hypothetical, because I'm going to ask, opposing counsel, I get it when they say, I'm buying an annuity and my beneficiary, if this goes on, it goes to my daughter. I get that there's not a sole benefit there. But I don't see why, if they buy a standard annuity and they don't name anybody, that it just seems like that's a classic sole benefit situation that fits exactly within the statutory language. So I'm confused. I mean, I understand you're forcing them to name you, or Medicaid's forcing that, but if they don't, it seems to meet the sole benefit language. Then I get confused, but go ahead. Mhm.
I think our position on that kind of hypothetical is twofold, Your Honor. One, consistent with the concurring opinion in the Hagedorn case, that kind of annuity, which is designed to hasten Medicaid eligibility, would be so contrary to the purpose, the most basic purpose of the sole benefit exception, that even if there were a textual argument for it being a sole benefit transfer, it wouldn't be sustainable. And two, even if it were, assuming that it were a sole benefit transfer, our position remains that C1F, the beneficiary naming requirements, trump the sole benefit exception in this circumstance. And I want to point to the Ninth Circuit.
Can I just ask you, as a matter of financial affairs,
Mhm.
to the extent you know, is there such an annuity? I mean, that is, whoever is doing the payout, they don't get to keep the money if the person dies, right? It goes to the person's estate. So the hypothetical posited seems to omit the reality that if the person dies and outlives the payout, there is definitely somebody going to get the rest, right? It could be the business that is paying out the annuity, which seems like theft. But it also could be the heirs of the annuitant.
Justice Wentland, I will say I have seen a lot of Medicaid planning annuities over the past 2 years, more than anyone would ever want to look at. I have never seen a single annuity in this world that doesn't name beneficiaries. I cannot say.
Can I ask a follow? I mean, I like that we're basing on your personal experience, but I mean, for example, judicial retirements, you get a payout if your spouse gets to keep it that's smaller than if you just keep it yourself. So I'm hesitant. I don't know enough about annuities to know whether this is factually correct or not, but is it so obvious that you can't, you just don't take a risk? I just don't know the answer to that. That there are two kinds of annuities, one where you get to name somebody and another where you're just gambling a little bit.
And I'll confess, I don't know the legal answer to this question. Is it possible to have an annuity that names no beneficiaries whatsoever? I do not know. All I can say is that I have never seen one in this context.
You were about to go to the Ninth Circuit case, to the Hutchins case, and before you do that, I have a simple question. I don't know if it's a simple answer, but the Hughes versus McGrath, the Sixth Circuit case came out around 2013, and we've heard radio silence from Congress since that case came out as to what happens with quote unquote sole beneficiaries and annuities.
And that, in our view, is unsurprising. We wouldn't expect Congress to make a change after Hughes, where Congress already made a change to deal with this precise issue in 2006. There would be no reason for Congress to make a second amendment to do what it already did. The act in its original form in 2005 required that the designation be made to the extent of the benefits paid for the annuitant. And then in 2006, Congress changed that language. It amended it to require that the designation be made to the extent of the benefits paid for the institutionalized individual rather than the annuitant. And that change really goes to the very heart of these cases. On its face, it draws a distinction between the annuitant, the person named on the contract, and the institutionalized individual, the person applying for Medicaid. And it contemplates that those two people don't have to be the same. And bear in mind that there are only two.
Mr. Boodoo, why didn't they use the word institutionalized spouse then? Because that would be clearer, wouldn't it? Why would they? Go ahead. Mhm.
I'm sorry to interrupt. I think to the contrary, that would be far less clear. All of the asset transfer rules under C1, including C1F, apply to transfers made by unmarried applicants, married applicants, and the spouses of married applicants. So if C1F sub 1 had been amended just to refer to institutionalized spouses, then on the face of it, it would have suggested that the provision doesn't reach unmarried applicants, which would have been frankly illogical and inconsistent with the whole statutory scheme. Ultimately, Hutcherson in the Ninth Circuit and later the Superior Court decision in Breslau look at this amendment and both find it clear that the very point of this amendment was Congress saying that the beneficiary naming requirements have to reach annuities like these. And that conclusion really gets us almost all the way there in these cases, because if we agree that the 2006 amendment was intended to do just this, then ordinary canons of construction require us to interpret the whole statute in harmony with the 2006 amendment. The most harmonious interpretation, in our view, is the one that was adopted by the Superior Court in the Breslau case, which holds that community spouse annuities are not sole benefit transfers in the first place. As a plain text matter, these community spouse annuities in these three cases cannot be called sole benefit transfers because the community spouses are not the sole beneficiaries, where contingent beneficiaries are also named. That is the view of the CMS opinion letter from June 2005 that's discussed in our brief. It's the view that New York adopted in the Addington versus Dowling case.
But does that mean that the sole benefit has no meaning in annuities whatsoever? Is that, because if we adopt your view, every annuity is covered, right? There's not, that whole sole benefit has no application in the annuity context. Is that your view?
Yes, and the order in which Congress proceeded here, the specificity of the annuity related provisions, the plain meaning of the 2006 amendment, not to mention the federal guidance on this and the practice throughout the states, all confirm that there was never supposed to be any interaction between the sole benefit exception from 1988 and these Deficit Reduction Act provisions from 2005 and 2006.
They're going to get up and say the opposite. They're going to say that the sole benefit provision takes you completely out of that transfer period. That if you do something for the sole benefit of the spouse, that it's not an improper transfer, so we don't need to worry about any of this. So you want to address that up front. I understand your point about specifics, but if you look at the way the statute includes this, it does it in the context of improper transfers, right? And it excludes something that's a sole benefit from the improper transfer altogether, right?
Right.
So given that they're going to say that, it's not quite so simple that the more specific controls the general, is it?
Well, if we make the assumption, as the family beneficiaries do, that these annuities are sole benefit transfers, and we obviously disagree with that, but if we assume that, then what we get at that point is a conflict between their position and the 2006 amendment to the Deficit Reduction Act.
Well, not if the Sixth Circuit's correct that the way of resolving the conflict is saying, okay, this is meant to deal with sort of cute annuities, ones that aren't market-based annuities that, that are clearly, you're getting these kinds of balloon payments, or you're naming your daughter or your son. That's what it's about, not legitimate annuities that are really trying to figure out how long you're going to live and how much you get. And they're going to say that. So
when we look at the Sixth Circuit decision in Hughes, what we see is that the Sixth Circuit didn't acknowledge or grapple with the fact that there had been a substantive change to the Deficit Reduction Act in 2006 on this very issue. Now, I'm sure the family beneficiaries will argue that the Hutcherson case doesn't grapple with the sole benefit exception, and that's true too. There is no circuit case that is a plug and play solution here. The only
and can I ask, I mean, the Ninth Circuit and the Sixth Circuit clearly, do we have any other circuits now? This thing you'd think would be like litigated to the hilt and be in the U.S. Supreme Court at this point, but there's nothing else out there at the circuit court level?
there has been nothing else at the circuit court level. No. I see that my
Now,
time.
Can I ask you one more question?
Of course.
So the statute also says transfers to another for the sole benefit of the spouse. What would that entail then, in your estimation? Just transfers to a trust? Or why wouldn't that include an annuity?
No, we don't think it would include an annuity. And the most common sense interpretation of to another would be a trust or even a form of custodial bank account, but a form of transfer that is again a pure interspousal transfer that does not actually change the eligibility calculation, but a transfer that is designed to hasten eligibility really does not and should not fall within the sole benefit exception in the first place.
Can I follow up on that? Because I don't, a trust. So I have two rich spouses, and they're prepared to put into the money into a trust for the community spouse, shifting all the money into a trust for the community spouse. Is that legal? I'm confused by that.
Well,
if it's an irrevocable trust, can they do that? I'm just trying to understand, can they do something worse than what's going on here, which is transferring a market, transferring a market-based amount of money into annuity, as opposed to some kind of clever trust?
well, as long as no contingent beneficiaries are named, I don't know that it would be worse. I mean, the basic bargain that Congress has enacted here is that income to the community spouse is protected. So when married couples convert assets to income to the community spouse as a way to spend down into Medicaid, generally speaking, Congress has said that's okay. The problem becomes that the Deficit Reduction Act was designed to.
I have just a technical question. This trust idea can again, I've got Mr. and Mrs. Bezos, and they transfer all the money to a trust. Is that possible, or is there a way that the Medicaid prevents that from happening? You're in cahoots with your spouse. You're prepared to, have the community spouse get all the money in some trust. Is that legal? It seems wrong to me. I just want to make sure I understand that point.
Yeah, and I think it would depend on precisely how the trust is set up, Your Honor. And certainly our position would be that if there are contingent beneficiaries named on that trust, then it would.
I get it. That's easy. I'm doing my hypothetical,
right,
which is they just put all the money in trust. Because I take it if they, I don't know how that works. Because if that's okay, why is this annuity not okay? But so you don't know the answer on this trust.
I don't know quite the answer to that.
But if you broaden it out, why shouldn't we assume that this is not necessarily a loophole, but it's a way to protect assets so that the community spouse isn't left with nothing? Why shouldn't we assume that that's the point of this?
And the basic bargain of the Deficit Reduction Act was to protect community spouses. Under our position, Chief Justice Spud, a community spouse will earn every penny of income from the annuity for as long as they live. And if they live out their actuarial lifespan, then all of the money will go back to them as income. But the Deficit Reduction Act, and not just this provision, but other provisions of the Deficit Reduction Act as well, the requirements that other forms of transactions, loans, promissory notes, mortgages be actuarially sound. They were all designed to limit strategies that both spend down individuals into Medicaid in ways that are designed to pass the wealth on to heirs. So the competition in these cases, so to speak, is most certainly not between the state and the community spouses. The community spouses will get every cent of income for as long as they live. The competition, so to speak, is between the state and the heirs. And this may be the first and last time I ever cite George W. Bush in oral argument, but his signing statement got it right. The Deficit Reduction Act was about limiting spend down loopholes that allow individuals to qualify for Medicaid while passing wealth to heirs. CMS has said the same thing, that these provisions were intended to, quote, discourage the use of annuities to shelter funds for heirs while qualifying for Medicaid. That's volume 2 of the Mondor appendix at page 168 to 69. And if there are no...
Just one more question. If, you know, given the fact that there's this split, why should Mass Health get the benefit of this, you know, this difficulty, this ambiguity in the language?
Well, we don't see any. Are you referring, Chief Justice Budd, to the contractual language or the statutory language?
I'm thinking about the contractual language, the annuity where it's, you know, where you're allowed to the part where it says the existing, to the extent that benefits have been paid language. And I know you talked about that a little bit, but it seems just, it's ambiguous because it doesn't talk about who we're talking, you know.
Mm-hmm. Well, in our view, Chief Justice Budd, we don't see any ambiguity in the statutory language. Like Hutcherson, like Breslouf, we see the 2006 amendment as making this clear. Every case, as far as I know, to have ever considered the meaning of institutionalized individual here, Breslouf, Hutcherson, Hagedorn, have held that the institutionalized individual is the person in a nursing home, the person for whose Medicaid benefit the annuity is purchased. And the contractual language here, the Commonwealth, again, we see language like that elsewhere, like in the Hutcherson case. This language incorporates the statutory scheme. So we don't see any ambiguity either in the contract or in the statutory scheme itself.
Any other questions? Okay, thank you very much. Next we have Attorney Neely.
Morning, Your Honors. May it please the court. My name is Lisa Neely, and I represent the appellee Laurie Dermody in this matter. These cases are about so much more than an analysis of the extremely complex Medicaid statute, which we've just talked about, but they're really about Mass Health's failings in seeking to perfect reimbursement claims from spousal annuity contracts and in properly following or implementing these regulations in the first place. Along with this has come tremendous administrative confusion, along with judicial chaos, as cited by the number of cases in the Commonwealth's briefs with varying beneficiary designations across the Superior Court. I would just like to go back to a comment that one of the justices made early in Attorney Boudou's presentation about how come this is just happening now, how come this has not been consistently applied. And I did receive that same question at the Superior Court when I was arguing the Dermody matter. And I think if you look at the record and some of the materials in the record, you will see that the Commonwealth has interpreted this provision in different ways. Going back to my case at the Superior Court proceedings, when the Commonwealth took the position that an annuity purchased like this for the community spouse, if it was actuarially sound, it met the sole benefit standard. The Commonwealth made that concession. They agreed with that. And they actually said during those proceedings that there was no case they could find to support their proposition. that a sole benefit transfer that was actuarially sound, like an annuity, didn't somehow meet the statute, that there was nothing to support that. With respect to the meaning of the term sole benefit, the Commonwealth has claimed in these proceedings now that it's undefined, that there's no definition, that it means you can't have contingent beneficiaries. But the CMS guidance, which the Commonwealth has cited to portions of that in their pleadings, not while omitting other portions of it, clearly defines a sole benefit transfer as being, quote, fairly restrictive definition, in that it requires that any funds transferred be spent for the benefit of the spouse within a time frame actuarially commensurate with the spouse's life expectancy. And that's in the CMS guidance. There's no reference to this not meeting the definition if it's a contingent beneficiary. In federal courts, including the Hughes case, another federal court, in the MERS v. Houston case.
But if you expressly name a beneficiary, isn't that going to violate the sole benefit? It's clearly not for the sole benefit.
It is for the sole benefit during this individual's lifetime, and that is what the CMS guidance, the HHS, and these federal courts look at, and that's how it has been interpreted.
That's how, when we read through these regulations carefully, these impenetrable regulations, are we really going to find that it says sole benefit means for the sole benefit of during their lifetime, or are we going to find it's much more ambiguous than that?
I don't think it's ambiguous at all, because the CMS.
I know you don't think it's ambiguous, but is the language ambiguous?
I do not think the language is ambiguous once you read the Medicaid transmittal or the state Medicaid manual, and you look at the federal court cases that I've cited. And the Health and Human Services also supports the definition, in addition to, and I did not cite this in my pleadings, but the Social Security POMS, that is a term of art in Social Security law, sole benefit. And they also specify that is for the sole lifetime benefit of the beneficiary. And you see this coming up quite a bit in the special needs trust context. I know we're not talking about special needs trusts, but in the special needs trust context, a big, what Social Security does is they look at are these funds being used for the sole benefit of the special.
Even if we have one that's not actuarially sound, your view of that's fine too. If you create some kind of huge balloon payment, and their named beneficiaries, the kid, that's fine too in your view? That's because it's a sole benefit while he's alive, but there's a giant payout when he's clearly going to be dead, or she's clearly going to be dead.
I think that the sole benefit definition is an actuarially sound lifetime payout with no balloon payment. So how this is typically done is you look at the Social Security tables, and in the example, or in my client's father's case, it was I believe a 5-year term annuity, and it paid out in equal payments. And that was an actuarially sound lifetime payout because the intent was he was the only beneficiary to receive these funds during his life, and he just prematurely.
I mean, we're asked to decide sort of a more difficult problem. I mean, yours was actuarially sound. They're all actuarially sound here, all three of them, right? We don't have any shenanigans going on here. So it's the equities, are complicated. We're stuck with pure statutory interpretation.
Mm-hmm.
It's not like the Medicaid or the Attorney General's being unreasonable here. Basically saying you're entitled to the money during your life, but if we paid out for the spouse, we get it rather than the heirs. I mean, there's not really a public policy problem on either side here, but we got to make sense of the statutory language. It's confusing.
Is your point, counsel, that the statutory language that we're not going by the plain ordinary meaning of sole beneficiary, but that the agency has defined sole beneficiary as actuarially sound? Is that your position?
That is correct, that it has a a meaning within the Medicaid context, and that is revealed by looking, for example, through the state Medicaid manual, and that you're not applying the dictionary definition of soul.
So I have a sort of another practical question. What is to prevent the community spouse from putting all their assets into an annuity, so long as the payouts are actuarially sound? Is that even sort of mathematically possible? I guess because I'm concerned about persons hiding assets by converting them into income using an annuity by putting all their assets into the annuity, so long as it's actuarially sound.
I mean, I think if you look at the example in my client's case, Mr. Hamill, I mean, he had roughly a couple $100,000 from the sale proceeds from his home, and he put that into an annuity so that, which was actuarially sound, so that it could generate income for him to pay for his assisted living expenses because his wife was in a nursing home. So if they paid privately for both items, their resources would have been depleted very rapidly. So under that analysis, his annuity was actuarially sound. It fits within the definition of what the sole benefit rule was designed to capture, which is to protect a community spouse from becoming impoverished because their spouse is in a nursing home and they also need income and resources to live on. So I think in that example, those were primarily, the majority of his assets. But all of these
would prevent a, say, wealthier community spouse from putting assets into an annuity, converting it into income, so long as it's actuarially sound, I guess. And then, at the end of the day, they die, and then the heirs get it under your interpretation of the statute, which is exactly what the whole system was designed not to do.
Well, I think that there is a give and take within the statute where reimbursement clauses are balanced against the actuarially sound standard. So you have the actuarially sound, and this is also contemplated in the Medicaid manual, where they talk about with this sole benefit transfer rule, there's a possibility that a spouse could take assets. Congress has not put a limitation on it, and transfer those assets out of their control or purview. But as long as those assets come back to them in an actuarially sound manner, whether by a trust, which was blessed in the Hagedorn case from Michigan, or one of these annuities, that is the protection that Congress has put in place, and that's in the state Medicaid manual as well. So I think an example where there would be something that would need to be curbed, or what was designed to curb that type of behavior, is if you had an annuity that wasn't actuarially sound, that was almost always designed to pass wealth along. I mean, in these cases, it's presumed that the individual is going to outlive the annuity term. If you did like a 20-year term certain annuity and then tried to qualify for Medicaid, that would not qualify under the sole benefit rule, because then it's outside the term, and really, then it would implicate, for example, the beneficiary designation. And that's the example that I've used in my pleadings, and that's how I've reconciled the statute, and that is how the Hughes court looks at it, and I think that's how it's supposed to be harmonized.
Explain your example. I mean, is the reason your example doesn't work that 20 years is not the lifespan of the community spouse?
Right. I think in my example, in my pleadings, I said the individual was, 85 years old. I mean, his life expectancy under the Social Security tables at that point would be, maybe 5 or 6 years.
So what if I get an annuity at age 85? I put all my assets into it, and it's a 5-year annuity. Can I do that?
You can do that because it's actuarially sound. It's within your life expectancy. So an 85-year-old, like say, for example, Mr. Hamill, they may need money for their own care, which is very, very common. You see now many spouses.
But I think Justice Wendland's asking you a harder question, which is, say someone's really very wealthy. They have $20 million. Can they get themselves an annuity that pays them? And they're 80 years old, and they have a life expectancy of 5 years. Can they buy an annuity that will pay out all of that money in 5 years and that be fine?
In my opinion, a very wealthy individual like that would never want to go on Medicaid. I mean, you know, an example.
Well, but
I
that's,
your own care at home. I mean, you could have top of the line care. You could set up
no, but I'm just saying again, we're dealing with, you know, the evil spouse. The evil spouse wants their spouse in a nursing home, and they want to walk off with the $20 million. Can they do that with, as long as they do it in an actuarially sound way? I'm just trying to understand that.
Well,
I'm not sure it's a nice thing to do, but could you do that?
I mean, there's no limitation placed by Congress. I've been asked this question before, and there is no limitation. Would a person with $20 million ever?
But then does that suggest that Mr. Boodoo may be right then? If you can do that, our focus on actuarially sound may be misleading because it's just how much money you have, which is, so that's, I'm concerned about that.
Well, I think, again, that's balanced with, I think it's the actuarially soundness protects against that, because the point is to get income back to the community spouse. If Congress wants to put some sort of cap on it, they can do that. They have not done that.
Right, and that's only if we accept your interpretation. But if we accept Mr. Boodoo's interpretation, that does not happen.
What does not happen?
That the heirs inherit a lot of money. That you can use this annuity in a way to avoid paying back what the government has paid for the institutionalized spouse, and guarantee that your heirs instead get the payments.
Well, I think because if it's an actuarially sound standard, the point is that you're not doing it as a wealth preservation strategy. Like, you know, if you
aren't you though? Because you're hedging your bets, right? If I need to use it all during my lifetime and I use it all up, great. If I don't, if I die earlier than the actuarial tables say I'm going to, I get to send it to my spouse, to my beneficiaries, my heirs, when the government has paid, you know, a ton of money to take care of my institutionalized spouse. I mean, this is a method of sheltering assets, right?
I don't think it's a wealth preservation strategy. I don't think it's a method. I think it is a method to preserve assets.
So if that's the case, then why shouldn't the rest of the money go to pay for the money expended for the institutionalized spouse?
Because under my interpretation of the statute, under the sole benefit rule, there's no reimbursement requirement. That is not the standard under that rule. It is under the sole benefit exception. If you transfer assets for your sole benefit or to another for your sole benefit and you're a community spouse, as long as the payout is actuarially sound, that shows that the intent is to benefit you during your life, not as a wealth preservation.
Well, I understand.
Wait. If I could just ask one more question about that, because it just seems to me that Mr. Boodoo's position is more in line with the point of the Deficit Reduction Act, right? Because that's what we're trying to do. Make sure that the money goes to where it's been expended by the government. And so I'm just trying to figure out how your position, I understand your position, but how does that work with the Deficit Reduction Act?
I think that it works to curb long annuity terms that are almost always guaranteed to pass wealth on to the next generation. And that's what was discussed in the Hughes case. Like, if you can't have a 20-something year annuity and still qualify for Medicaid benefits. There's also, the way I read the statute, and I've discussed in my pleadings, the C1F, with reference to the institutionalized individual, it doesn't state who the purchaser of the annuity is. So from how I perceive that, is it's unclear with respect to who it applies to. So I think that the goals of Congress have always been to protect a community spouse and implement reimbursement provisions where they see necessary. And most of the time with those reimbursement provisions, you see them applicable to individuals trying to shelter their own assets without a community spouse. So I talked about pooled disability trust. Like if you're over 65 and you want to transfer assets to a pooled trust for yourself, you can do that and get on Medicaid, but the state has to get paid back. If you're disabled and you put assets into a special needs trust for yourself, there's a reimbursement provision. So it's very clear. With respect to community spouses, you can transfer your home to your community spouse, and there's no reimbursement provision to the state when the community spouse passes away for the, with respect to their estate. So I think Congress is clear in that it allows a community spouse to retain unencumbered assets, and I think the sole benefit rule is part of that. And I don't think that was left undisturbed by the Deficit Reduction Act. That's how I view the statute and read it and harmonize it with, having it all read together and with, with the Hughes case as well.
Justice Laurie, did you have anything?
You asked my question, Chief.
Oh, okay. I'm sorry. All right. Thank you very much. And we'll have Mr. Larrea.
Hi, thank you, Your Honor. I want to follow up on the conversation you were just having about the $20 million that the spouse has. From the time that this law was put in place, a spouse did not have to cooperate. And that's routinely done in other states, such as New York. And secondly, in the DRA, they opened the idea of using a sole benefit promissory note. So without a payback to the state. So if we're reading the intention of Congress as wanting to have a payback, why did they open that up? Because that's what the $20 million person could do instead.
Could you explain what that, because your brief I thought was very interesting and on these sort of clever stuff. So explain what you're just talking about, this the promissory note, with using the example of the $20 million.
$20 million. So let's say my life expectancy is 5 years. I could enter into a 5-year promissory note with the payback that mirrors the annuity without a payback to the state.
So who do you enter into such thing with?
You could do that with anybody. That's the ironic thing. You could do that with an 18-year-old grandchild. It doesn't specify in the statute who you cannot do it with.
So I can enter into a promissory note with Justice Cipher and say that I'm going to get my she's going to pay me back the $20 million over 5 years when I'm 80. Is that right? I can do that.
Yes.
And okay, now the trust example you mentioned in your brief, again, I've got $20 million and I'm not worried about my spouse. So what kind of trust can I set up?
I am not all that familiar with those trusts. They're not really done in this state. They're done routinely in Michigan. But you could essentially do a sole benefit annuity payout within the trust with no required payback to the state.
Well, you may be right. This is not a public policy case. This is a statutory interpretation case. But it seems based on your responses that the Deficit Reduction Act isn't the right title for the statute, and that we're talking about Medicaid really being able to be applied to upper middle class folks. And
well,
it just seems different than the initial intent.
Well, I don't think the intent was to make everything in the act draconian. I mean, they opened up safe harbors all over the place within the act.
So when they look at your property, I can't remember, it's like $130,000 the number. So if you have a promissory note to get paid $20 million, that's not included in that 130,000 cap.
Right. There would be a sole benefit transfer, and the spouse would be able to receive those payments and treat them as income.
So it seems like if you're within, even if you're within the 5 years with the 5-year look back, if you've got an attorney who understands this well enough, you're going to be able, as the community spouse, to protect assets, which is hard to reconcile with the whole point of Medicaid.
Well, there's been a movement across the country to expand Medicaid. In fact, California just voted last month, the legislature, to reduce all asset tests for their program. So I think maybe we're assuming that there's an intent to rein things in when there really wasn't.
Can you, back Justice Wendland's question, can you enter into an annuity that doesn't name a beneficiary? Is that possible?
Yes, yes. And actually, this fits right into what I wanted to say next. The difference between the two federal court cases is the Hughes case came later and asked 5 questions directly to CMS. And I've got it in front of me. You don't have it in the record, I don't think, and I suggest that you have your clerks obtain it. An annuity is for the sole benefit of the community spouse. If the annuity provides for payment of the entire value of the annuity plus interest to the community spouse within that person's expected lifetime. The entity selling the annuity is another within the meaning of the statute. So CMS has come right out and said, this is a sole benefit annuity. Spouse can buy a sole benefit annuity.
So again, Jeff Bezos can buy a sole benefit annuity, that pays out, his billions to himself over a 5-year period, and that's excluded.
Yes.
That seems
well
inconsistent with the whole statute.
Honestly, Your Honor, the wealthy are not looking to get the type of minimal care provided by Medicaid. They can get assisted living. Many assisted living facilities, which are private pay, provide the type of care that goes all the way to nursing home level. They can get home care. They don't want to be parked in a wheelchair in a hallway near the nurse's station. And that's what a lot of people wind up at. I'd like to.
No one wants themselves to be there. The question is, again,
can you do
it? My evil spouse hypothetical. It is right. Mm-hmm.
Right. So I do want to take a moment to go through the statute itself. I believe this is an unauthorized taking by the state agency. The agency's relying on its enabling statute for everything it's doing. The federal law that passed said that the agency can take the entire annuity, irrespective of what the Medicaid benefits would be. I mean, it comes right out and says that the agency then took that and put it into the statute. They did not treat it as a mandatory federal law for a decade. That's why the cases came up in 2017. They treat it as an optional state law, optional Medicaid provision. Why isn't this a matter for the state legislature? I mean, this is a taking. They could arguably take the entire thing. You could take your Jeff Bezos example here, and they could arguably, under the way they make the beneficiary, the Commonwealth, all of Jeff Bezos's wealth could wind up going to the Commonwealth. Now that cannot be authorized by the general language in the enabling statute for the executive office.
I'm confused by that. That can't be right. It's only the amount that pays for the spouse, the institutionalized spouse.
That's not what it says. It says at least.
Well,
it's the federal law says at least. The state reg says at least. You have to be the beneficiary for at least. The state, the Mass Health Agency is requiring that you make the beneficiary simply be Commonwealth of Massachusetts, which is the situation in the 2 cases that I'm involved in here. So arguably the state agency can grab the entire amount. That is a due process issue. because
I don't,
you,
where in the, I thought it says at least the amount.
right.
It's connected to the amount to pay for the, I mean, I don't know, that seems.
It says you have to be the beneficiary for at least
Yeah,
that
but that
amount.
seems,
It doesn't say that you can only collect for that amount. It says for at least that amount. That is a
I
huge
suppose
overreach.
in a hypothetical where the state did a money grab of the type that you're anticipating, that there might be a regulatory taking. But I don't think your position is that paying back Mass Health for the money it expended for the institutionalized spouse is unreasonable under the takings clause. That can't possibly be your position.
My position is that the way they're treating this is they're not putting any limitations. They're not tracking the federal
Which
law.
might implicate a regulatory taking. But to the extent they confine themselves to reimbursement for the institutionalized spouse expenses, your position cannot possibly be that that's a regulatory taking.
They're making you do it. When people try to put on the restriction, they reject the annuity beneficiary. That's what's happening. So I also want to quickly go through the actual statute.
Since you brought up the constitutional argument, I guess my question to you is, suppose Mass Health just limited itself to reimbursements for the institutionalized spouse. That would be fine under the constitutional analysis, right?
It might be, but where did they get the authority to enter into this taking of assets from citizens? The enabling statute says follow federal, you must.
You might be arguing that it's ultra vires or something to that extent, but not the takings clause.
Okay. What I'm
Can
saying.
can you just take 2 minutes to talk about the state statute? I just want to give you a chance to do that, and then we're gonna.
Which statute do you?
Whatever one you were gonna talk about.
Okay, the state statute gives the agency the authority to do things, but it doesn't come out and say you can take assets from citizens. The state legislature the last time the state legislature spoke, it wiped out the idea of going after anything other than the probate estate of the decedent. They spoke loudly and clearly that they didn't want the assets of citizens to be seized. Now, the federal law changed afterwards. They never went back to the state legislature. The email that we refer to in our briefs was written 3 years after expanded estate recovery had been rejected loudly by the state legislature. And in that email, they say, we're going to go after it. We can go after that. They never went back to the state legislature for authority to go after anything. So where do they get the authority? I mean, the federal government is giving them the authority. How does the federal government give a state agency the authority to go after the assets of state citizens?
Are you talking about the remainder proceeds?
Yeah.
Don't they automatically go to the beneficiary?
I'm not clear what you're asking.
Well, are you saying that the state hasn't authorized going in and physically taking the remainder assets?
Well, the state legislature completely rejected that idea as to your anything beyond your probate aid. That's 3 years before that email was written. And then they went and said in that email, and by the way, that email was written with the advice of 3 lawyers, because I've made a FOIA request that's come back all blacked out. So they knew what the federal law was at that point, and they went ahead and just brought federal law in to that was completely contrary to what the state legislature had just voted 3 years earlier.
Okay, thanks. Does anybody have any other questions?
Can I ask for just one clarification? So your point is that the federal law changed and the state legislature didn't make a commensurate expansion.
Right.